In this video, this woman right here accused a court marshal in Nevada of searching her inappropriately. Apparently, he took her into a room where it was just the two of them. He touched her breasts and buttocks and forced her to lift her shirt so that he could search her for drugs. Another court martial, after she complained about it, another court martial in family court, this guy right here, arrested her for the crime, and I'm using the word crime loosely, of making a false allegation about a peace officer, which in the state of Nevada is not a crime. The woman sued. They settled for $200,000. The court marshal was fired, and the headmaster, who didn't stop the court marshal from arresting the woman, this gal right here, was also fired. So, problem solved, case closed, everybody's happy. Notice the whole thing was on film, and it was audio recorded. So it was audio and video recorded. So explain to me how an audio and video recorded incident from Nevada is why Duval County, Florida, does not allow cameras in court. Especially considering that this case in Nevada came into being long after Florida's filming rules went into effect. This is the Florida Rules of Judicial Administration. And this is Rule 2.450. A is electronic and still photography. It is allowed, but the judge can limit it to control the conduct of proceedings before the court, to ensure decorum and prevent distractions, and to ensure the fair administration of justice in the pending cause. So basically, the judge can say if it is or isn't allowed in their court. They have very strict rules of how TV and radio and still photographers will work. You may notice that the audio system for radio broadcast purposes has to be hooked into the existing court facility's audio system. So if the judge mutes the judge's mic so the judge can have a conference at the bench with the lawyers, that won't be picked up by the radio broadcast or the TV. Or if the judges wish to confer with their clients and they mute the mics at their respective desks, then that also will not get picked up. You may notice that jurors can't have electronic recording devices. So they get removed from members of a jury panel, and they get returned when it's at recess. And there are good reasons for that. And use of electronic devices by others, same rules, control the conduct of proceedings, to ensure decorum and prevent distractions, and to ensure the fair administration of justice. And in the courthouse, the chief judge gets to control it, essentially for the same reasons. Now, why is all this? The reason why all boils down to exactly what they say: fair administration of justice. So these are some examples of things that you don't want to happen if you are on trial for something. You do not want the jury to record what's going on in the courtroom, because maybe the police officer testifies about something that your lawyer objects to, and it gets stricken from evidence. If the jury is doing their own independent recording, that is still on their recording, and if they go and review it while they're in deliberations, then they hear the evidence they shouldn't hear, which is bad for you. Also, if the jury is recording, then what they may not be able to hear with their ears, maybe they can pick up with their recording devices. So while you're conferring with your lawyer and you're telling your lawyer that you're so glad they didn't find the drugs that you had shoved up in your prison wallet, well, maybe the jury's recording device can pick that up. Recording devices can be more powerful than human hearing. The reason why it may not be to your advantage if you are on trial for something to have people in the audience audio video recording is because maybe opposing counsel knows that people can audio and video record in that courtroom, and he pays one of his paralegals to sit behind you, audio video recording you and your lawyer. So every conference that you have with your lawyer, where your lawyer dutifully mutes the mic so that the two of you can discuss whatever you need to discuss, it all gets recorded by that paralegal behind you. Everything that you write on your papers, that paralegal, he just holds up his camera a little higher to get the right angle so that he could video record everything that you've written on your papers. He could read your lawyer's notes. What could possibly be the harm in that? When you look at these things with how they could be abused, with the potential problems they will cause, beyond just the distractions of having people waving around cell phones in the air, trying to get the best shots, or moving place to place, trying to capture the right angles, beyond that, I'm sure you could see the abuses that could happen if everybody was allowed to film without any controls. So there are reasons that the courts prevent unfettered filming in courtrooms. And even in hallways. If you're wondering about hallways, it's pretty common for lawyers to, during a recess, like a 15-minute recess, to step outside into the hallway with their client, look around to see if anybody's within earshot, and discuss some key aspect of the case or some upcoming strategy or something. And if there's somebody out in the hallway recording it, just imagine that somebody out in the hallway recording it is somebody who's working for opposing counsel, who will then turn over that recording to opposing counsel so opposing counsel can combat your strategy. That's the antithesis of what our adversarial system is built around. In order to have fair administration of justice, we need to protect the confidentiality of attorney-client communications. We need to protect the jury from being exposed to evidence that they should not see. Remember, the whole point of the Fourth Amendment, the whole way to enforce the Fourth Amendment is through suppressing evidence. Any Fourth Amendment violations, the natural result of those is that any evidence found as a result of those Fourth Amendment violations gets suppressed. Prosecution does not get to use those at trial, which may lead to guilty people going free. But at the end of the day, if we don't prevent police from abusing the Fourth Amendment, then there's nothing restraining them from just trampling all over your Fourth Amendment rights. So if the jury is allowed to record, then all the prosecution has to do is accidentally let slip that well, we did find 20 kilos of cocaine in his car, but Fourth Amendment suppression hearing doesn't let us bring it into evidence. Well, now the jury has that. Every time they review the recording, they have it on the recording. There would be no way, like well, obviously a prosecutor may be subject to sanctions if he does something that blatant, but you get the idea. But if something comes out in testimony and your lawyer objects to it, it would then get stricken from a transcript. So if the jury wants to have the transcript read back to them, or however they're going to review the transcript, then the stricken portions would not be given to them. So any tainting evidence would have its taint minimized. But you get the idea. The whole point of these rules is for due process. It's for the administration of justice. I know that Mr. Freeman and others don't understand that, but the courts have held that your right to due process, your right to justice in the justice system, trumps your First Amendment right to record. Trials are still open to the public. You can still go there. You can still see them, but you just don't get to record them. You can take notes. You can draw pictures of what's going on. You just can't record them unless the court allows you to. So I hope you found that instructive. I'm not anti-First Amendment. I'm a strong believer in it. But your right to justice, in my opinion, should trump the First Amendment in the courtroom. And the courts agree with me on that. So thank you for watching and have a great day.